Hello and welcome to PGurus channel. I'm your host Sri Iyer. We are rejoining Sri G Mohandas on a very important topic today. Before I set out the topic and the details, let's first welcome Sri G Mohandas. Mohandas ji, namaskar and welcome to PGurus channel.
Namaste, namaste again.
So, sir, this is a continuation, if you will, of the series that we started about what Dr. Swamy had done about his politics. He is a man of many facets. One of them happens to be politics. The other one is activism. In activism, he has taken up several causes that others don't even think about going there. But it is always like somehow I see this thing that there are, like you explained, there are people who want to blame anything and everything on a certain individual for their own shortcomings. And it appears that this Twitter warfare hasn't stopped yet, and it continues to grow. And this is not something that is spontaneous. I can understand it if it is something spontaneous. It is not. It is planned. And one hint I want to tell: we know who is doing this. And if you have to, the thing will come out, the truth will come out. But it is our duty, as yours as well as mine, that we need to show how much work goes behind taking up each case related to any case. Doesn't matter whether it is Hindutva or other things. There is a lot of background work that needs to be done. There's a lot of prep that needs to go into it. So to talk about all those things, we're just going to take 5 or 6 topics that Dr. Swamy has taken up, and we're going to go through one by one, and we're going to start it chronologically where it all began, which is the Ram Setu. Before that, I don't know if Dr. Swamy had taken up any Hindutva causes, but Sri Mohandas ji will set me straight how things are, what happened, and each one of these cases. So you engage your seatbelts. You are in for a great ride. It is the next 45-50 minutes. You're going to have a series of stories and how at every step of the way mischievous politicians try to queer the pitch. They try to do a lot of mischief. But anyway, I don't want to ramble on. Over to Sri Mohandas ji. Please take it away, sir.
Yeah, yes. I'm not much battered or baffled about social media campaign. After all, campaign is anybody's right. And you cannot change the opinion of the campaigners because they have already taken a position and they are campaigning for that. So, whatsoever logic you present, they are not going to agree. So, just like they saw Swamy running away by after killing Sri Iyer. They can just go on repeating that. We will say there is no photograph, no video. No, they are so clever that they have not allowed us to take a photograph. But there is no CCTV camera. No, wo to kharab ho gaya hoga. This is the nature. Everywhere they will find fault with. And you cannot convince a campaigner because purely because he is a campaigner. So unko chhod dijiye. We will come to the legal fights which Swamy has taken because people are at times question his commitment to his Hindutva also. I'll tell you one non-legal fact. Okay, throughout Vajpayee's 13 months government, Dr. Swamy was the only man, the only MP who raised Kashmiri Hindus issue in Lok Sabha. Out of all the MPs, he was the only man who raised this issue. Okay, that is out of our legal parlance. So let us come back to legal thing. The first was, which I know, he might have fought several cases in Allahabad High Court, Madras High Court, almost every High Court. So I will start from 2007. When he was still running the Janata Party, he was probably the lone stalwarts in Janata Party. Everybody deserted Janata Party. And from that point onwards, he were called single man army. And you see, it's such a huge army that he is alone. But you see, Himalaya also is alone. I'm taking these words from Atalji's mouth. Atalji said this: "हम अकेले हैं, लेकिन हिमालय भी अकेला है." Oh, that was the situation of Swami. Probably even today it is so. What happened was, Ram Setu, which British were calling Adam's Bridge. That is underwater bridge between India and Sri Lanka, supposedly constructed by Vanar Sena, so that Ram and his army can cross the waters and kill Ravana. This is what Ramayana says. Anyway, there are environmental problems also if we destroy this Ram Setu. Problem was, every vessel, every ship coming from the west has to circumvent or circumambulate Ceylon, Sri Lanka, and then come to Tuticorin or Visakhapatnam or Paradip. So to reach Bengal Sea from Arabian Sea, you have to travel a lot of south and then towards north. This is the situation even today. So the shipping lobby in India was always asking for a route between Sri Lanka and India, which will straight away allow them to reach Tuticorin. The only hurdle was Ram Setu, because Ram Setu's from the water surface, Ram Setu is hardly 5 feet, somewhere it is up to 20 or 30 feet. So no vessel can cross it unless you break it. So this Setu Samudram project was conceived by predominantly DMK leaders who are interested or having a share in shipping business, dredging, everything. It was probably T.R. Balu who forced such a decision on NDA government of Vajpayee. And in principle, the project was, yes, sir.
So in one of his video speeches, Dr. Swamy had mentioned this. You can go back to YouTube and get more information. He said that T.R. Balu had two wives. One ran shipping business, one ran dredging business. That is why he was so keen on Setu Samudram. Please continue, sir. I'm not sparing anybody today. Go ahead.
Anyway, probably I'm not capable of making such comments, because I don't know how many wives generally politicians hold. And I don't have any problem they are having more than one wife or something like that. That is their personal matter. Anyway, so this Setu Samudram project was, in principle, approval was given by Vajpayee government, which was finally the go-ahead was given in 2005 by Manmohan Singh government. In fact, Sonia government. And somewhere in 2006, the Sangha Parivar took up the issue, saying for environmental reasons and religious reasons, cultural reasons, isko todna nahi hai, because we need this. And Ram Setu is having tremendous environmental importance also, because the thorium deposit along Tamil Nadu coast is primarily due to Ram Setu. The tsunami, which did not hit Kerala seriously, it hit, but not, it could have engulfed if Ram Setu was not there. Ram Setu took the energy out of tsunami so that it hit in a lighter manner in Kerala. These are all environmental importance of Ram Setu. But in spite of that, people are in search of money, so they went ahead with the project. And the RSS was angry. RSS announced a Chakka Jam agitation throughout India one day. And then the things precipitated. Sudarshan ji, the then Sarsang Chalak of RSS, contacted Dr. Subramanian Swamy and asked him to take a legal route to stop this nonsense. Previously also, somebody in Ramanathapuram district went to the municip for stopping this project. Somebody went to Madras, some court somewhere. Somebody in Lucknow tried to move a public interest litigation, something that also failed. So सब कुछ fail हो गया था. So then Swamy was called in, Generally, when you say Swami is a Hindutva warrior, the first shout will be, but he is not an RSS man. True, he is not an RSS man, even today. He is not a member of RSS. But he was a sympathizer of RSS, supporter of RSS, since his 1964 at least. So RSS had no problem with Swamy. And for political reasons, he has even criticized RSS. But still, RSS doesn't have any problem. So RSS contacted Swamy and told him we might do something. And Swamy moved Supreme Court in 2007 and got a stay order in 2007 August. And that stay order is still in force. It has not been converted into a judgment. So from 2007, it is continuing. Then 2009, Swamy went to again to Supreme Court, saying that this UPA government will play some mischief. They are appointing some committee, of which the report will not be made public, and one day they will break the Ram Setu. But nothing happened. Supreme Court said, okay, we will look into that, etc. And the years were going by. Here I must say that if some people allege that Swamy is not taking his cases to logical conclusion. What is that logical conclusion? How can you take your case to a logical conclusion if the court is going on adjourning the case? You cannot force anything on the Indian court. Ab dekho, the recent Shabarimala judgment, when was the petition filed? We don't like the judgment, that is another thing. The petition was filed in 2006 and the judgment came in 2018 September. For full 12 years. Now, Swamy is fighting for protecting Ram Setu. It is already protected. It is already protected. Now, nobody can destroy it because there is a Supreme Court stay order. But if the government declares it as a national monument, then the coming government, whether NDA or UPA or whosoever is coming, because it is democracy, you cannot expect a particular government to last indefinitely. The government may change, government may come and go. Ram Setu has to be there, for which you have to declare it as a national monument. Now, Swamy moved another petition. In 2013, there was a conspiracy to break the Ram Setu without the knowledge of Supreme Court. Because once it is broken, it is broken. What is that Supreme Court can do? After all, they can take some contempt action on somebody. That is all. So there was a move and there was huge halla in parliament. And you know who spoke in favor of Ram Setu? It was none other than Yogi Adityanath. He was Gorakhpur MP at that time in 2013. And I quote from Lok Sabha debates. Now you may ask me, why are you quoting from Lok Sabha debates? Because press can go wrong, or they may intentionally misquote. TV channels can go wrong, they can edit it, they can do whatever they want. But parliamentary debates cannot be edited, it is freezed. जो बोला है हमेशा के लिए. You can withdraw it later on. मेरी गलती होगी, मैं उसको correction कर रहा हूं, but the original record will be there. Now you see, योगी आदित्यनाथ saying, सभापति महोदय, मैं आपके माध्यम से एक महत्वपूर्ण मुद्दे की और सदन के और ध्यान आकर्षित करना चाहता हूं. What is that मुद्दा? महोदय, केंद्र सरकार ने सेतु समुद्रम परियोजना के संदर्भ में गठित आरके पचौरी समिति की रिपोर्ट को भी खारिज किया है. There was a committee to find out the feasibility of Setu Samudram project. Committee said it is not feasible. The government discarded that committee report. That was an indication that government is forcibly going ahead to break this Ram Setu. That was what challenged by Yogi Adityanath and Vijay Kumar Malhotra, so many other people also. So Dr. Swamy approached Supreme Court saying that now Supreme Court should direct the center to declare it as a national monument. And even that application is still pending with the Supreme Court. In 2020 February, means last February, Dr. Swamy got a posting and he said kindly issue necessary direction to Government of India. But court said we will consider it after 3 months. And then this corona lockdown came. Nobody could move court, and court is also moving only for emergency matters. In between, Swamy met every minister in the cabinet, every minister. He personally went to every minister, met them, told them the importance, everybody. But nothing moved. I don't know, some bureaucratic play in between. You might be having better idea than me about the bureaucrat and how they play. Even if a man with the iron will like Modi is at the helm of affairs, bureaucrats know how to do their or play their game. So I hope I don't find any other reason that why it should not be declared as a national monument. It should be declared at the earliest. So this is one case which everybody was elated, but mind you, the case has not reached its logical conclusion. Now let the viewers decide who is not bringing the case to logical conclusion. Is it Supreme Court or Government of India or Dr. Swamy? Dr. Swamy has been repeatedly approaching Supreme Court for getting a decision, but he is yet to get a decision. And one declaration by Union of India will kill the issue once for all. That is also pending. And one order from Supreme Court to Government of India to declare it as national monument, that will kill the issue, but that is also not happening. And who has to face the blame? Dr. Swamy has to face the blame, because you are not bringing it to logical conclusion. अरे ये लोग कभी कोर्ट में कचहरी में गए हैं क्या? You go and see the delay in the courts, and there is delay. What is that you can do? Only few men fret. Nothing can be done. So you have to painfully go through that process. Wait for, continuously wait for the result. That is what legal fight is. And Swamy never goes to the street and sit in dharnas, etc. That is not his way. He always adopts constitutional methods. Okay, you may have your opinion. He is not taking his cases to logical conclusion. Then what prevents you from approaching court and take up these issues to logical conclusion? What prevents you people to campaign for Ram Setu? Nobody prevents you. Instead of running this negative campaign, haranguing somebody, deriding somebody, defaming somebody, you do some positive thing. You call yourself Hindu warriors, protectors of Narendra Modi. Are protect karo, but do something positively also. You will not do that. Your mind is full of negativity. Yes, sir.
Now, you were halfway through the statement of Yogi Adityanath that he made in the parliament. I kindly complete that, and then perhaps we can go on to our next topic.
महोदय, ये सब जानते हैं कि सेतु समुद्रम परियोजना के लिए अगर श्री राम सेतु को तोड़ा जाता है तो ये वहां की पारिस्थितिकीय तंत्र के लिए खतरनाक है और वहां के समुद्री जीव जंतुओं के साथ साथ प्राकृतिक संपदा, क्योंकि थोरियम का जो विशाल भंडार भारत के अंदर है, उसमें सर्वाधिक उसी क्षेत्र में है, उसके भी नष्ट होने की प्रबल संभावनाएं हैं. So Yogi Adityanath is not arguing on religious point, he is arguing on environmental point. And then there are a lot of interruptions going on. He is completing one sentence by other sentence. It will be quite boring for people. I'll tell you the date of the debate is 19th March 2013. As I told you in the last our discussion also, anybody can go to Lok Sabha website, take the debate on 19th March 2013, and the subject is interesting, regarding alleged conspiracy to demolish the holy Ram Setu. This is the subject of the debate. So you can yourself read that debate. And I think Yogi Adityanath is still a powerful man. so that at least he can request government of India to make this declaration, or he know how to get the things done.
Well, viewers, please pardon us for the noise disturbance. Mr. Mohandas' neighbor has a small daughter who likes to have her opinion also expressed through this debate. But it will be there for a bit. There are controllables and there are uncontrollables. So the next question that I'd like to go on to Mohandas ji is, there was this concept of Sharia bank that the UPA government was very keen on implementing. See, this is the danger of a coalition government. If you think about Manmohan Singh's government, the DMK was pulling towards this. They probably had some equations. They wanted to do this thing, like I mentioned, that certain minister was very keen that this be done, and so on and so forth. Likewise, there were some Kerala constituents, perhaps, who wanted the Sharia bank. I'm given to believe it was Kerala that was very, very keen on establishing a Sharia bank. To know more about this was a very dangerous move. India does not have special provision for any other law. There's only one constitution, and everyone is required by law to follow it. If you're born in India, you have to follow the law. In fact, even if you're visiting India, you're still bound by the Constitution of India. That is the rule, law, and order of the country that you're visiting. So please enlighten us a little bit more about the Sharia bank, where it started, how many people you faced who turned you down, and then how it was finally taken up by Dr. Swamy. One thing that people should remember is that whenever Dr. Swamy takes up the cases, there is nobody to pay him any money for taking up the case. This is mostly out of national interest, Hindutva, preservation of Hindutva, preservation of Sanatana Dharma, or preservation of a certain lifestyle which has been enforced for thousands of years. So please continue, sir.
Now, the year was 2010, and there was communist government, LDF government in Kerala. They issued a notification saying that their industrial department is going to invest as shares in a forthcoming Sharia bank, Islamic bank, what we call. And major shares will be with the government, and a few individuals also will be included in that. And the names of the individuals, everything was made public. Now it was as you know, Islamic bank is a big fraud being committed or perpetrated on Muslims themselves. Intelligent Muslims understand Islamic bank is a fraud anyway, but it gives a signal that we are with the Muslims, we are going to take care of Muslims. And you know who prepared the ground? In 2009, this Raghuram Rajan committee was formed by RBI for banking sector reforms. The very same Raghuram Rajan who later became RBI governor. Now, Raghuram Rajan submitted a report in which he recommended Islamic bank also. Now, Kerala government took a clue from that, and they said, we are going to start a Sharia bank. Now, banking is a sector which constitutionally belongs to Government of India. State governments cannot start any bank. They can only start cooperative banks which are falling under NABARD, not under RBI. And some masala is going on now, but that apart, the fact was that the very act was unconstitutional. I spoke to several of my colleagues. At that time, I didn't have an LLB degree. Even if I had, there was no point in going to Kerala High Court with my stature. Everybody was afraid to touch the issue. Then a senior RSS Pracharak told me that somehow you have to block it. Talk to whomsoever you want. I asked, can you speak to Dr. Swamy? Do you have any political problem? He said, RSS doesn't have any problem. What nonsense. You speak to him. But then still, since Dr. Swamy was away, he was in Delhi, or at that time, I think Guwahati or somewhere, I could not reach him. I decided to meet our S. Gurumurthy in Chennai. First, I went to him. I told him the problem. He said it is very difficult to get a relief as you want, because in principle a community can run a bank, they can run a bank. There is no provision that you prevent it. I said, the more than running a bank, the signal which is going to the society is worrying me or worrying us. Then he said, it is unlikely that, anyway, you will not get any relief from Madras High Court at all. Don't go to Madras High Court. You try in Kerala. I said, anyway, the decision is by Kerala legislature. So I have to go to Kerala High Court only. And then I told him I am going to meet Dr. Swamy. Gurumurthy said, okay, fine, meet him and tell him my opinion also. Gurumurthy said so. Then Swamy came to Cochin for giving a lecture, wherein he is the chairman of the Academic Council of SCMS Institute, a Management and Engineering Institute. Annually, he used to come there for taking classes for a day or two. I went there and I met him, told him. He said, Mohandas, find out some of your RSS friends to fight him, because I have to travel a lot from Delhi to Kochi. Every time the case is posted, I have to fly in and fly out. It's a huge thing. And do you have money? I said, obviously, I don't have money. I don't have that type of money that I finance you. It is unimaginable. Oh, you want free service? You want to take me trouble? And that too for free, spending from my pocket, I have to come. I said, sir, you have to come. Are kya hai? Then first he asked me, show the notification. And within 5 minutes, he told me, see, I will get you a stay order on this, but I don't know the final outcome. I am not sure. What did Gurumurthy say? I said, the Gurumurthy said such and such things. He said, okay, let us see. After all, it is judge's decision. We cannot influence them beyond reasonable limits. And it is their mind ultimately takes the decision. Then he went to Kerala High Court. He extended his stay. He stayed back in Cochin. Next day itself, he went to Kerala High Court. And day after, he got the stay order. And it was big news at that time that the Islamic Bank has been stayed. Then there were at least 10 to 12 postings of the case, and the judgment came in 2011. In fact, Dr. Swamy's petition was dismissed. Why? Because Reserve Bank of India under Y.V. Reddy, they took a strong stand that Islamic Bank is a nonsense. We cannot allow this in India. We are not going to grant permission to any Islamic bank whatsoever. Then government of Kerala submitted a list of 6 private Islamic banks already working with your license. Then during next posting, RBI filed an affidavit saying that we have cancelled the license of all 6 private banks which you have noticed. So they were also affected. This strong stand, I was told at that time, was taken because Pranab Mukherjee was the finance minister. And when Pranab Mukherjee says something, Manmohan Singh generally don't disagree, because Pranab Mukherjee was a respectable figure. In fact, many in Congress thought that Pranab Mukherjee would have been a better prime minister than Manmohan Singh. But Sonia clearly know that once he make Pranab the prime minister, then it is gone. She cannot have any control over him. That was the problem. Anyway, RBI took a strong stand. Therefore, Kerala High Court said, without going much into the merits of the argument, we are disposing this petition because RBI is not going to allow this bank to function. So that was the end of it. Anyway, no Islamic bank as of date is working in India. You will see so many advertisements, we are Islamic bank. They are not Islamic bank. You go in and find out what is happening. Is it according to Sharia law? Nothing. They might have been employing a mullah, somebody who is sitting there with his dadi. That is all what they do, not more than that. They cannot do, because the moment it is known to RBI, RBI will cancel their license. However, you can carry on with an Islamic bank without RBI license if people believe you, you are that much credible to take deposit, not pay interest, and still run a bank, because the foundation of the bank is the interest. Banking system is based on interest, and without interest, what is the bank? So it's all fraud. But you can continue to do this fraud in your private manner without taking or getting an approval from RBI, for which RBI will not be responsible. Any Tom, Dick, and Harry becomes a financier nowadays, and one fine morning he is disappearing. You know that. Such an operation is still possible at the lower level, ground level, but not with the permission of RBI, not as of now. So this was done by Swamy. I was touched because everything he paid from his pocket, including his 5,000. I must openly admit that I didn't even offer a tea. In fact, he was offering tea for me during the hearing. That was the situation. But he didn't personally give any advertisement for that. And you know what he got in return? His mobile number was collected by somebody, because courtroom used to be jam-packed with Muslims as well as Hindus. And advocates also who want to know how Dr. Swamy is arguing a case. He said text, from which you can learn so many things, how to argue your case. So the courtroom was always jam-packed. And Swamy, so many people asked his phone number, he gave it liberally. And what did they do? The Muslim majority district in Kerala, Malappuram, they put posters with the Swamy's mobile number saying, 5 lakh loan without collateral, contact this number. And Swamy started getting a lot of calls asking for 5 lakh rupees loan without any collateral. He was frustrated, finally he has to change that number. I still have that old number of Dr. Swamy. Dr. Swamy's number was changed in 2011, you can see. This was what he got in return. I don't think anybody appreciated him for his services. I felt very bad. Then, number 2 was his security within Kerala was to be raised because of Islamic banking case. A mufti dress policeman, police constable, with a revolver on his hip was always accompanying Swamy, apart from the usual security thing. At that time, I think Swamy was in Y category. Now he is in Z or Z plus, I don't know. Z plus was only for Tamil Nadu at that point of time. In Kerala, it was Y. If he goes to Tamil Nadu, it was Z plus because of the LTT threat. Kerala, it was Islamic bank threat. Everywhere he was threatened. And now you see, the people who say that he is not a Hindu warrior, what is that he did for Hindus? He has not brought his cases to logical conclusion. And all these people, they are even afraid of disclosing their identity on Twitter. Most of them, they are all anonymous people on Twitter. अरे Twitter में तो identity दिखाओ, डरते हो बहुत. While Dr. Swamy doesn't have any anonymous handle, he is tweeting from his own handle. He is roaming around the country even after this threat. Whether security is there, ठीक है, नहीं तो नहीं है. Because he came for campaigning in 2014 elections to Trivandrum. In between, there was no security at all. Because security from district to district, they change police vehicles. एक डिस्ट्रिक्ट वाले ने छोड़ दिया, दूसरे ने टेक ओवर नहीं किया. आप क्या करें? जब तक उसकी गाड़ी आती है, वेट करें मेन रोड पर. नहीं, better we decided we will keep moving. When the police join, we'll join. So Swamy, with zero security in Kerala for around 45 minutes or 1 hour, then police came rushing in. He is traveling openly. His Twitter ID is open. Everything is open. And जो लोग उनको criticize करते हैं, वो सब anonymous है. Most of them are anonymous. Maybe somebody कितने हैं वो लोग मुझे पता नहीं. किसी का नाम रखा है खन्ना या गुप्ता. वो रियल है या anonymous है किसी को बोल नहीं सकता हूँ. Therefore, I will not blame everyone who is campaigning against Swamy for being anonymous. But a lot of numbers are anonymous. That is true, because from the name itself you can distinguish that. Khair chhodiye, that was the story of Islamic Bank.
Let's move on to the next topic, which is the Chidambaram temple. Mohandas ji, kindly take us through that episode.
Dekho, I didn't know anything about Chidambaram temple. I was, the year was 2012 or 13. I went to Delhi for some other purpose. And whenever I go to Delhi, I pay a visit to Dr. Swamy also, if he is available and he can give me an appointment. And I went, we were speaking together. Then some pujaris came to his house. It was in that Nizamuddin East house. Some pujaris came. They are from Chidambaram. They were speaking Tamil. Bare chest people with their holy veshti. They came and literally they were in, from their face, I could guess they are in real trouble. Then only Dr. Swamy came to know that Chidambaram temple has been taken over by Karnataka government, and already an executive officer has been posted to look after the temple. The temple does not belong anymore to the Pudu Dikshitar community, which was owning the temple. Now there is history behind that. Previously also government took over somewhere in 1951. And these people fought up to Madras High Court and got a favorable judgment. And in 2012, again, Karnataka government took over the temple. They challenged, but they failed. So they approached Swamy. Swamy first fired them, saying that you should have approached me initially. Now you have failed and then you are coming, it is very difficult. Then anyway, he took up the case because it is a public Hindu cause, not a particular small community. Chidambaram temple is so historically important to Hindutva, so that we are duty bound to protect it from governmental interference. So Swamy went to Madras High Court. Dr. Swamy also failed. He came to Supreme Court with an appeal. And there he won the case. That was in 2014. When Justice Sadasivam was the Chief Justice. Now, Sadasivam himself belonged to Tamil Nadu, so he understands the importance of Chidambaram temple. And the judgment was given in favor of this Pudu Dikshitars. It is not Swamy fought for getting any control over Chidambaram temple. As of now, Swamy is not even a committee member of Chidambaram temple. He has not taken 5 pies from Chidambaram temple for fighting the case in the High Court or in the Supreme Court. He was not offered any chair, not he received any chair of office ruling this Chidambaram temple. कुछ नहीं लिया है, खाली दिया है सब. That community may be eternally thankful to Swamy, but Hindu society as a whole should be thankful to him for this effort. It is very easy to dismiss somebody by trivializing. वो क्या इतना बड़ा क्या है, आपने केस डाला और कोर्ट ने जजमेंट दिया. अरे जाके तो देखो कोर्ट में, ऐसा जजमेंट नहीं मिलता है तुमको, इतना जल्दी भी नहीं मिलता है.
So I'm curious, Mohandas ji, before we go to the next topic, under what grounds did the Madras High Court reject it, and what did he have to do in the Supreme Court to overturn the High Court judgment?
The thing is, Madras, High Court is having a tendency to go with the legislature. They will find out reason to support the government, because a legislature is supposed to have more wisdom than judiciary, because these people are elected people and we are unelected people. So generally, court will refrain from interfering with government decision. This happens in Supreme Court also. It is a legal principle also that court should not interfere with government policy unless it is affecting your fundamental right, etc. Now, what happened in Chidambaram case was, this Putu Dikshitar is a community. You know, the word in the constitution is denomination. Putu Dikshitar was accepted as a denomination by Madras High Court in 1951. The denomination is vested with the rights of Article 25, that they can, Article 25 and 26. In 26, it is said that you can administer your religious institution. Denomination has a right to rule your temple. Therefore, what happens is, every denomination within the Hindu society will have a right to administer their temple. But Hindu society put together don't have a right to administer their temples. Therefore, क्या होता है? The public temples are always with the government, and private temples are generally with some community or the other, wherein the court can call it a denomination. Now, this was overlooked by Madras High Court, but Swamy brought these points to the notice of the Supreme Court. Moreover, there is an article in Constitution, that is 31A, that if the government takes any property for mismanagement, for the reason of mismanagement, government can take over private property. But you have to remove the damages, rectify it, and then you have to give it back to the original owner. You cannot eternally keep the property with you. On these 2 points, Swamy argued, and Supreme Court was convinced, and so many other small details also. Finally, he got the judgment in favor of him. That is why you might have noticed all my friends, like T.R. Ramesh, etc. They always say that Hindu society will be declared as a denomination. All Hindu societies put together should be declared as a denomination, or a definition of denomination shall be included in the constitution, so that Hindus are also included. Now, what happens is, Muslims have their denominations. Muslim as such is not protected by Article 26, but Muslim denominations are protected. So every Muslim belongs to a particular denomination, either Shia or Sunni or Madhabi, Jamaat, so many. Christians also, they are Protestant, Catholic, then Pentecostal, Marthoma, Orthodox, Jacobites, several denominations. They all get, but Hindus are not divided in these religious lines. Now, you know, an Orthodox Christian will not go to a Pentecostal church. He will not go. And even if he goes, they may not admit him also. But for Hindus, I may be having, my community may be owning a temple, but I can just walk into any community's temple without any restriction. So community is there, but it is not based on a particular system, or rather say caste-based groups are there, but not religion-based, because we consider all gods are same. I go to Shiva temple in the morning, and in the evening I go to Mahalakshmi temple. God and goddess, everything is God for us. So this advantage became a disadvantage in the constitution, because while interpreting constitution, the word denomination was given interpretation from Oxford Dictionary. That means a group of people believing in a particular God, having a prophet or guru, and having a common style of worship. Now, you see, Hindus never had a common style of worship. You go to every temple is different, no? Different style of worship. Somewhere you have to remove your shirt. Somewhere you can be with coat and suit. No problems. Both are temples, and both are ways of worship. Nobody has imposed any restriction. कि ऐसा ही करो, ऐसा मत करो, ऐसा किया तो we will expel you from the community. ऐसा नहीं है. So what happened? this advantage goes to the minority communities and the majority community is deprived of the thing. Now, this judgment, this definition was given in 1954 in Sirur Mutt judgment, the famous judgment which everybody refers while discussing temple thing. Now, I think it was 7-judge constitutional bench. Now, Supreme Court has referred these type of things to a larger bench, 9 judges bench, including Sabrimala issue. The core issues they have referred to, they formulated 8 or 9 issues and referred to the larger bench. And you don't know when the larger bench will decide on the fundamental or core issues and then resend it back to the original bench for decision. Anyway, that exercise is going on. At present, we are at Hindus are at disadvantage because of this word denomination. Now, our law minister knows this. Ravi Shankar Prasad knows this very well. Everybody in the legal field, see, Ravi Shankar Prasad is a Supreme Court advocate. He knows right from 1954 Shirur Mutt judgment to 1978 SP Gupta judgment, the same principle was followed by Supreme Court. So unless there is a legislative intervention, Supreme Court is not going to change their definition. Because they cannot, they set a precedence and they will go by precedence. Otherwise, they should have some other reason to change their interpretation, some valid reason. Sir.
Now, if you look at how the Indian Constitution in Hindi interprets the word denomination, it calls it Sampradaya. Now, Sampradaya makes a lot of sense for Hindus. They understand what Sampradaya is. You are belonging to a particular community. There may be another gentleman who might be belonging to your own community, but living in a different city, different state. And when the two enter into a matrimonial alliance, that is when all these things come to the fore, where the parents might discuss, according to our Sampradaya, we do this ritual. According to our Sampradaya, we have to do. You understand where I'm coming from? That is what Sampradaya means. Now, unfortunately, the Supreme Court only follows arguments in English. Perhaps that itself should be looked at. This is just my opinion, sir. Please continue.
I think the original text of the Constitution is in English. Later on, it was translated into Hindi and approved maybe by Government of India. But which is the original text? I think original text passed by the Constitutional Assembly was in English. Therefore, court will go with the original text. This is one reason for bringing up the issue to the Supreme Court. But this is, in my opinion, this is not sufficient to convince the Supreme Court because you have made the word denomination was translated by you into Sampradaya and you are defining what is Sampradaya. Is it not? That is how it goes because it's a second step only. Through translation, you are introducing an equivalent word and that equivalent word is being defined by you. So Supreme Court may not agree for such arguments. Tell me, sir.
Well, you see, parts of Indian Constitution are borrowed from the Irish Constitution. In Ireland, denomination is everything. The country is divided into two because of the fact that a particular denomination feels it cannot live with the other denomination. With such a stark line of descriptions, I think that needs to be looked at by the lawmakers. I mean, why would you want to take an Irish constitution, borrow from it, and use it on a country that is essentially Hindu? I'm just using loud, sir. I mean, like you said, I'm in agreement with you. Some legislation needs to be done to make this thing correct. But if there's anything else you want to add on this topic, please do so, and then we can go on to the next topic.
We'll better go to the next topic because see, this is all this denomination problem is almost known to everybody in this legal field, especially who is entangled with temple. In fact, my friend P.R. Ramesh, some 6-7 years back, I think it was in 2012 or 13, in a meeting, he asked me, Mohandas ji, In your opinion, what is the biggest hurdle of freeing temples from government? I said emphatically, my answer was, it is the word denomination in the constitution. That is the biggest hurdle of taking out your temples from government control. With that remark, I think we'll go to the next subject.
Yes, sir. So the next topic we're talking about is something that is very close to your heart, Mohandas ji. This is about the control of Kerala temples. So I think you had a big role to play in this one, isn't it?
Yeah, true. See, Kerala temples, around, if you take a medium and big temples, there are approximately 8,000 temples in Kerala, out of which around 3,000 temples are controlled by government. Rest 5,000 temples are controlled by private entities like trust or individuals or local committees. But government control is government control, and a lot of mismanagement is going on. So I tried challenging this act itself. It is a 1950 act. It is very difficult to challenge because almost how many years? 60 years have passed, 60 or 65 years. So after 65 years of the act in existence, you go to court and say that I find this unconstitutional. Court may throw you out for coming and troubling them. पैंसठ साल आपको unconstitutional नहीं दिखा, अभी दिखाए क्या? This is a logical question, and they have asked for. So I spoke to Dr. Swamy, and we decided on a course of action that I'll file the petition and make Dr. Swamy a respondent, so that prima facie it will not be dismissed. The case will not be dismissed. We know merit is on our side, but still judges may refuse to look into the merit. You know, a legal term that is calling dismissing in limine. So without going into the detail, he is a troublemaker unnecessarily. Don't spoil our time. They just dismiss the petition and send you out. That is called dismissing in limine. So to avoid in limine dismissal, in spite of we having merit on our side, we decided this course of action that I'll be the petitioner. I'll make Dr. Swamy a respondent along with government of Kerala and this Devasam boards. And I sent notices to various Hindu institutions also, Hindu organizations also. It was in 2015. The case went to 2017. 2 years it took. Like the old days, Dr. Swamy used to fly free for me. And he did the job. We got a favorable judgment, but High Court put a rider in that. Though we don't agree with the following points of the petitioner, we agree with 1 or 2 points, and we express our distress that the government of Kerala is doing such things. It is high time that they bring necessary changes, etc., etc. Then they said, however, we don't have powers to pass orders on the government. Okay. Kya karenge? The judgment is like that. We went to Supreme Court. In Supreme Court, we slightly changed the strategy. And Dr. Swamy is the first appellant and I am the second appellant. Because Swamy is in Delhi, whenever the case is posted, he can rush to Supreme Court. I am in Kerala. I cannot rush to Delhi every time. So I became a supporting petitioner and he is the leading petitioner. Now Supreme Court has initially they heard some arguments, but then they registered it as a civil appeal. And now we don't know when it is going to come because the court is not functioning. Otherwise, Dr. Swamy could have mentioned it. It was live till 2018 January. And from 2018 January, it was converted into the other route of civil appeal route, which is very slow, which can take 5 years, 6 years, 7 years, etc. But you have a provision that you make a mention it is a constitutional issue, it cannot be kept pending for long. Then if court is convinced, they will make immediate postings. But now it is not possible. So I have faith in Supreme Court because the merit has been approved by High Court. They only say that we don't have powers to give direction to the government. Now, our opening remark in Supreme Court will be that, see, High Court is convinced that it is an anti-constitutional. The act is anti-constitutional. It should be straight away struck down. But they say they don't have powers. Now you have powers. Use that powers. You need not go into the wisdom of the High Court, because High Court has already, they have conducted so many examinations and they have reached the conclusion. Only thing they don't have, they say that they don't have powers to implement it. Please implement that. That will be our first argument in Supreme Court. And I think Dr. Swamy and the second petitioner, myself, we have a 90% winning chance in Supreme Court, so that we can bring Kerala temples out of government control by providing a good alternative also. Though a petitioner is not supposed to give alternative suggestion to court, being responsible citizens, responsible Hindus, we decided that we will give them alternative also, and the alternate suggestions, everything is already with the government. They are not implementing it, what to do. Anyway, that is the status of Kerala temple case now.
Now to the most important one, Ram Janmabhoomi, Ram Mandir, Sri Mohandas ji. This one is something that saddened me when the credit was misappropriated. The whole world knows who did what. So please state before us the facts of the case, how this even saw the light of day, how it was sitting in moribund, and nobody wanted to even take up the case, and so on and so forth. So please take it away, sir.
See, Ram Janmabhoomi is a civil case. The land belongs to Nirmohi Akhada or Ram Janmabhoomi Nyas Trust or Sunni Waqf Board. This was the question to be decided. Now, Allahabad High Court in 2011, they decided that this land be partitioned into three, or ek ek tukda teenon ko de do, so that 2/3 will be going to Hindus, 1/3 will be to Muslims. That was not a settlement which nobody agreed to that. Arey kya panchayat hai, kya vagara chillana ho gaya, and everybody came on appeal to Supreme Court. There were a lot of intervening petitions also. Intervening petitions were piling up. It came to the level of 32 or 33 petitions, intervening applications, not petitions, including the urban Naxal gang of Prashant Bhushan, Vrinda Grover. All these things, they were also in Supreme Court. That please listen to us before deciding this issue, etc. Now, the court was not listing the matter. Ab kya karega? So at that time, Ashok Singhal told Dr. Swamy, देखो मेरे जन्म में ये मंदिर बनेगा ऐसा मुझे नहीं लगता है. So I am handing over the responsibility to you. Now Dr. Swamy took the responsibility. He filed a separate petition. You know, problem is it is a civil dispute, land dispute between three parties. Now a third party, not the fourth party. In case you are called third party, the first parties are the litigants. An outsider cannot enter into a civil dispute because you have no stakes. Aapka hai kya? Whether the land belongs to you? No. Then why are you coming? This is the first question court will ask. If you have a claim, you have a genuine title deed with you, okay, we will entertain you. Otherwise, no. Now, how to get into the case, and getting into as an intervener is a risk. The intervening application, finally, you don't know whether the court will entertain the intervener or not. In one stroke, I have seen it in Islamic Bank. Last minute, a Muslim group came rushing in, saying that please listen to us. There is an intervening petition. Court said, no, we have made up our mind. We are reserving the issue for judgment. No, we will not entertain. Bas ho gaya. Because whether to entertain an intervener or not is the decision of the discretion of the court. They can just throw away your intervening application without showing any reasons. No, we are not entertaining anybody else. It is the end of that. So Swami know the risk, so he didn't take the route. He didn't want to put his head in this title deed so that it will get dragged on and on. So what he decided was, he filed a writ petition saying that a title deed jiska bhi ho, whether it belongs to Nirmohi Akhada or belongs to Sunni Waqf Board, I have a right to worship there. That right to worship is protected under Article 25 of the Constitution. Why? Because the Allahabad High Court came to a conclusion that there was a pre-existing temple below this disputed structure. That is a fact. Archaeological Survey of India has confirmed that. That means there was a temple. Once a temple, it is always a temple because of the Prana Pradeshta. Somebody may damage it, somebody may take away your murti, but that Prana Pradeshta will be there. Prana will be there. So, based on that, there is a UK judgment based on this, which Swami won for Tamil Nadu. Somebody lost a Nataraja Vigraha, and it was found in UK while auctioning. Swami went to UK court, fought it, and then got it back. That's another story, the old story. Anyway, Swami took that judgment also and argued in the court that my writ petition will stand because my right to worship is a fundamental right, and right to property is a statutory right. Fundamental right will always override statutory right, because to construct a house is your statutory right, but to breathe normally is my fundamental right, because it is a right to live. So if your house is preventing my breath, it is so close to my house, then my right will override your right of constructing a house. This is how the Constitution and other acts are made. Therefore, you can own a property in which there was a temple belonging to some other community. Even if you are the owner, that community can worship at that spot. And only Hindus have this Prana Pradishta, neither Christians nor Muslims. And Muslims can construct a masjid somewhere else. So Swami argued that you give my right to worship in Ayodhya, and eventually, if we find that the land belongs to this Sunni Waqf Board, so be it. We will give compensation to Sunni Waqf Board. Government can take over any land and give compensation to you, because owning up land is not a fundamental right. It was a fundamental right, but it was removed by Indira Gandhi from the list of fundamental rights. It is a statutory right now. So any land can be taken over by the government. Only thing, you have to give adequate compensation. That's all. So Dr. Swamy argued that you give me my right, I will arrange compensation for him. This was the initial argument. What did the Supreme Court do? That they posted this writ petition along with the original civil suit pending before the other bench. Swami said, okay, I will go and argue at the other bench. But the issue of the case was not being listed. Swami filed an application that day-to-day listing may be done, day-to-day hearing may be done. Then Chief Justice asked Deepak Mishra, he said, you get consent from everybody, then let us see. And Swami went to all these people, including your OIC, everybody. He wrote letters, he sent emails, he met personally. All these litigants he met, and he got signature for, we are ready for day-to-day hearing. And he submitted this to Supreme Court, that day-to-day hearing may be started. But still, Supreme Court delayed it. Deepak Mishra said, I will start this in January. but he did not do. It was again pending, and finally Deepak Mishra retired. And then came our Gogoi. Gogoi took up the matter and listed for day-to-day hearing. The first thing, in fact, Deepak Mishra did one good thing was, he dismissed all intervening petitions. But he could not dismiss Swamy's petition because it is a writ petition, not an intervening petition, sent by some other co-judge. भैया आप ये मैटर देख रहे हो, इसको भी देखो. What the new bench can do is, they cannot dismiss Swamy's writ petition. They can either go into the merits and decide, or send it back to the original bench. Both, only two options were there. Even government of India argued that you may dismiss Swamy's petition also. Only this civil litigants are sufficient to decide the issue. But Swamy stood up and said, no, mine is a writ petition sent to you by some other bench. If you don't like it, you can send it back to the original bench. You just cannot dismiss it. Deepak Mishra said, that is logic, and there is a reason behind that. It's my co-judge. It will be insulting for him. He is sending a paper and I am sending it to dustbin. What is this? So he decided to keep it pending. And what Gogoi did was, Gogoi decided this title suit first. And the title suit went in favor of Hindu groups. So what happened to Swamy's petition? It is as if Swamy has already won, because you are getting the land and your right to worship also. So Swamy's petition, in one way, what they in legal parlance they call infructuous. But still, what the judges did was, they didn't dismiss Swamy's petition. It was sent to the original bench, and probably original bench may one day decide that it has become infructuous. And now, tell me, who brought this to a logical conclusion? Was it government of India? See, it's all in public domain. You just Google, you will find out all these dates, everything, what is done, what is not done. Ram Janmabhoomi was a big issue. Nobody could have done anything. All these court proceedings, you can go to two Twitter handle, Live Law and Bar and Bench. You go back, you will see their tweets, what happened in the Supreme Court. You go to Bar and Bench and Live Law, or you just Google. If you are lazy, you can just Google. You will get all these details, newspaper reports, TV channel reports, everything. So this is what happened. And I don't think people are unaware of this fact. But the orchestrated campaign, when you start, it is, the meaning of orchestration. That is what is being done. So that is the story of Ram Janmabhoomi.
Sir, that was a fascinating conversation. I actually was only asking questions and making some observations there. See, the key takeaway from this discussion, viewers, is there are a lot of you who are independent, who are capable of independent thought, who are capable of coming up with informed decision. An informed decision comes about when you look at both sides of a story, and then you evaluate based on the facts, what is the truth? And it is our endeavor to tell you the facts of each one of these cases, which is why G Mohandas kept saying that I am reciting what was told in the parliament. There cannot be any kind of change in the wording. So most important thing is, many Indians, many viewers, it doesn't have to be Indians, anyone who's watching, you need to judge a person by his deeds, and you also need to look at what kind of obstacles that are being placed in his way by many, many people who don't want. See, there are two problems here. One is the people who are placing obstacles cannot do anything. They can't even pluck a hair. Second thing is they have a vested interest in letting things be in a certain way. The third thing is sheer incompetence. Fourth, jealousy. You have all these things forming a potent cocktail which is what is playing out now. Again, this is a factual rendition of various cases of Dr. Swamy for the cause of Hindutva. He has done such things for many, many other things. There is something called Melvisharam, there is Malappuram, there are so many other places where he was fighting for the rights of Hindus as minorities. So we can go on and on. He also has gone on a hunger strike for the cause of Hashimpura victims. These are all Muslims. Show me one Owaisi, show me one Muslim leader who has gone on a hunger strike to death. He didn't eat for 6-7 days, and doctor started telling him that he'll need to do something about it, otherwise his organs will start failing. So there is a lot of stuff that this man has fought because he loves his country, and so should each and every one of you. But please, those of you who are still continuing to spew venom, this is bad karma. That's all I can say. Thank you very much, Mr. Mohandas. And we'll be back with more interesting conversations from you. Again, you did a lot of research for coming on this hangout. It's not easy. You spent many, many hours.
Yeah.
And I thank you from the bottom of my heart. And I'll let you have the last word, sir. Please go ahead.
Just one information. Dr. Swamy is still under legal process for Hashimpura victims. The case is still live. The incident is of 1987, I think. And still the case is live. It has reached only district court. Because, very powerful politicians are in the dock, I think, including Mulayam Singh Yadav. The prosecution is so delayed that from 1987 till date, it has reached only to district level. Now he has to go to High Court and then to Supreme Court. Kab hoga pata nahi. And people say, you are not bringing it to logical conclusion. Are jaake wo logical conclusion karo na bhaiya. You take up the, who is preventing you from taking up public causes? You can take the public cause and sincerely show how to do things. Now, see, there are parallel petitions, Swamy has to face another menace. Swamy files a case. People take copy of that, change the names, etc. And after 2 days, you file the petition. What happens is when the registry, Supreme Court or High Court registry, when they saw that same matter, 2 petitions have come, okay, they club it together. And you go on advertising that I am the man who is fighting in the court. Swamy is fighting in the court. This is called a parallel petition, or in fact, parasitic petitions. While cancelling 122 licenses in you know who was the parallel petitioner or parasitic petitioner? It was none other than Prashant Bhushan. After Swamy filing the case, he also comes and files the same case. And now he goes tom-tomming around the world that I have fought the case. Anyway, he is a good lawyer that way. I will not, I'll call him urban Naxal, but he is having good legal acumen also. Anyway, these things happen in the thing, but Dr. Swamy goes without caring for this type of criticism or campaign. So that's all, IRG. I'll close.
Thank you very much, sir. And once again, namaskaram. And viewers, please subscribe to our channel. It's your support that keeps us going. This takes a lot of hours of dedicated work to try and get our facts right. There is no point in trying to fight lies with lies. We stand for the truth. That is why we are always with Dr. Swamy. And he, because our barometer is truth, that is where we all meet. Thank you very much. Namaskar.